Check it. Many people are. Many people are. Fine. Fine. Man, I'm ready to talk. Man, I'm
You all should mute your mic, please. Mic.
your mic now. Mm-hmm. No need.
The class rep on mute, so the class rep will speak on behalf of the class anytime I need to get a response. Class rep, are you there?
Yes, sir. Good morning, sir.
Alia,
Yes, sir, I'm here. Good morning, sir.
on mute and speak to me. Can you hear me? Hello?
Yes, sir.
Hello?
Hello, sir.
Alia, can you hear me?
Yes, sir. I can hear you. Can you hear me, sir?
I need to confirm that there is communication before I proceed.
Yes, sir. Yes, sir. I can hear you.
Good morning.
Recording in progress.
Okay. Okay, just hold on. I need to move from my phone to my laptop because calls might come in and they begin to disturb the flow of the lecture. So just a minute. Yeah, good morning. I need the class rep to unmute and maybe respond to my call
Yes, sir. Good morning, sir. Can hear you, sir.
so that I can be sure that everybody can hear me. Hello, unmute please and speak. Can you hear me?
Yes, sir. I
Am
can
I
hear you,
audible
sir.
to the class?
Yes, sir. You are audible.
Aliyah, unmute and speak to me.
Hello, sir. Yes, sir. You are audible.
Oh, very audible. Okay. Okay, good. That having been confirmed, I think the lecture can start. I'm aware that you have started and you're already looking at a source of law, Nigerian law. That is the English law. I would not know if Prof has completed that, but even if he has not, he will come back and do it. So today we are going to be starting with Nigerian legislation as a source of law in the Nigerian legal system. So at the end of this lecture, we should know what is a legislation, vis-a-vis Nigerian legislation. They will also be looking at the types of statutes, Nigerian statutes that we have or have had, as the case may be. Then we are going to look at primary and subsidiary legislation. And finally, we'll be looking at the legislative process. So in case you cannot hear me, if there's any break at any point in time, let me know, because I may not know. So it means Aliyah may have to call me directly or at least find a way to get in contact with me. Yeah.
Yes, sir.
Thank you. So what is a legislation? Unlike customary law, legislation is said to be the conscious efforts of a set of people to set laws for the regulation of society. So it is a product of a deliberate and a formal expression of rules of conduct, which is made by the relevant lawmaking authority. Now, you have to understand that to call it legislation, it must be made by the relevant lawmaking authority. And that is the body that is recognized by the law of that country as having the right and the legal capacity to enact laws. And this could be a parliament or indeed a military council in the event of a military government. So any person who claims to have made a law or enacted a legislation who is not empowered by the law of the land to do it will be acting in vain, because that law will not have the force of law. So it is only laws made by persons empowered with such laws in a country that recognized as law stricto sensu. And the nomenclature of laws will depend on the type of government that you have in place. For example, in Nigeria, a statute can be referred to as an act or a law. And then in the case of military government, a decree or an edict. Then for local governments, that is law made by local governments referred to as a bylaw or regulation. One thing you must note is that legislation is very important and perhaps is perhaps the most important means of regulating conduct in a country. It's a very vital instrument for social engineering and nation building. And basically understand that it is used to meet various means, or diverse needs in a complex and dynamic society. If I may explain, the society is dynamic, and the things come up from time to time that previous laws may not have contemplated and taken care of. So, and once such conducts come up, and it is intended that either a particular line of conduct should be encouraged or discouraged, and there has not been any law covering that, it is the enactment of a statute that is normally done to ensure that is effected. So it helps in social engineering. It helps to build the nation. And it is law also that will be used, to come up with new laws or indeed to abrogate or amend existing laws. So legislation actually does a lot in this regard. Now, in a democratic society, legislation involves representation. And representation in the sense that, as we have in Nigeria at this point in time, our lawmakers have been voted. Let's take it that they have been voted. Well, once they are declared, they are voted, regardless of whether they were rigged. But we take it that they have been voted into positions, into the legislative houses, both at the federal and state levels, to cater for the interests of their constituencies. So that's why they are there to make laws, to introduce bills that they think are necessary for development of the society or maybe perhaps their own constituency. And in that way, they are taken to be representing the people. So the laws, when enacted, are taken to be a reflection of the wishes of the people. In military governments, in a parliamentary government or in a situation where we have parliament, so I'm not talking parliamentary government in terms of what we have in the UK. This is where we have legislative houses. For example, there are rules and regulations that they must follow. That's a procedure before laws can be enacted. And even in the military administration, even though the procedure may not be as complicated as we have it, or maybe elaborate as you have it in a democratic setting, they also have minimum rules and formalities that must be followed before they can enact their decrees and uh, and edicts. Now, even though there are legislative powers, there is something that also helps to curtail the possible excesses of those legislative powers, and that is the Constitution. The Constitution, I'm sure you all know the Constitution. Let me say that if anybody has any question as the lecture progresses, the person should just please raise up their hands. And then once I see it, I will pause the lecture. Then we'll let the person express himself or herself. So I was going to make the point that even though powers have been given to lawmakers, whether uh, the House of Reps or Senate, or indeed the military, those powers are curtailed to some extent. There's a check on those powers. And that check can be found only in the provisions of the Constitution. We all know that the Constitution is a fundamental law of the land. As a matter of fact, I will eventually discuss, the Constitution itself is a statute, but it's a statute of a different kind. It's a statute of a higher status compared with the other laws. We'll still come to that. So, but basically, the Constitution acts as a check on legislative powers, because number one, whatever legislative powers the legislators are exercising, those powers are conferred by law, especially the Constitution. So if they purport to exercise their powers and they act outside of the powers conferred upon them, they can be brought to book, using the provisions of the Constitution. And the Constitution provides for a special procedure, by which laws can be made or amended. So to that extent, legislators must comply with that procedure. Otherwise, that law can be struck down by a court. In the case of decrees, well, the point there is that even though military governments come and suspend the Constitution, they don't suspend all the provisions of the Constitution. So what it means is that those parts that are suspended cannot operate, but those ones that are not suspended will operate. And the military government can also be challenged based on the fact that the action go against the provisions of the unsuspended parts uh, of the Constitution. So the Constitution is very vital and very important, even as a source of law uh, in Nigeria. So the Constitution itself, like I did say, is also a statute, but a statute of a special kind. So the Constitution itself can be amended, but the Constitution has provided for the procedure can be amended, and that procedure itself must be strictly followed. Where it's not strictly followed, the law, the courts will step in and declare the process null and void. Null and void. That briefly is talking about what a legislature. In the case of Nigeria, we know that legislation emerges from our law-making bodies. We have a federal system. We have the federal governments and the state governments. At the federal level, we have the House of Representatives, and the Senate. Those are the bodies responsible for making laws for the federation as a whole and the Federal Capital Territory, which falls under. So that is a bicameral legislature. As for the states, we know that each state has a House of Assembly. As the House of Assembly that is empowered in each state to make laws for the states. Then every state also has a local government, and they have their local government councils headed by the chairman of the local governments. They have their limitations as to the kind of laws that they can make, but when they do, the laws are referred to as bylaws or regulations. So every legislature has their limits. You know, maybe by now you know that the federal legislature cannot enact laws, having to do with areas that fall within the legislative list of the states. That is the residual list. They can make laws under the exclusive list as well as the concurrent list, just as the states can make laws on subjects in the concurrent list, as well as those ones in the residual list. Now, maybe I should also just make the point that talking about the power of the constitutions to regulate legislative powers and conduct. In the case of the military ordinarily suspends vital parts of the constitution. So to that extent, when it comes to lawmaking, the constitution will not have any power over them in terms of the laws that they make, basically. But they can only have problems when they make laws that go against the tenets of the spirits of the unsuspended part of the Constitution. And basically, the part of the Constitution that's never suspended by the military is usually the part that has to do with fundamental human rights. And as you proceed in your studies generally, not necessarily in this course, you will come across cases where legislative acts or perhaps actions by military governments have been found to go against the provisions, that's the unsuspended provisions of the Constitution of Nigeria. So at this point, any question? Okay, if I can't see anyway, I already made the regulation that if anybody has any question, you shall just put up your hand. Okay, I can see one hand. Ali, I think it's Ali.
Yes. Yes,
You
sir.
can
Sir, can you hear me?
Yes, okay, unmute and speak.
Yes, sir. So I wanted to ask how the military go about suspending the constitution. Like, how do they know the part to suspend, what not to suspend? Is it what they want to follow that they will not suspend,
Okay.
and what? Yes, sir.
Yeah, okay. Number one, talking about the how. There is no military coup that has been staged without the connivance of civilians, nay, lawyers, and the rest of them. So basically,
Why did
the
you cry?
parts that are suspended,
If I don't,
please,
I'm
whoever
teaching me
is,
that, and you tell me I don't. If I give you instruction,
who is this person is talking to us now? Please, when you are in class, please separate yourself, because you can imagine that if I had to give this lecture from a car park, nobody will hear anything. So please separate yourself and ensure that you keep away any kind of disturbance. So basically, they normally suspend parts of the constitution that may interfere with their powers to legislate and also their powers to rule. That is talking about the the powers of the legislation and the powers of the executive. You know, they don't operate the way the legislators operate. Under the constitution, there is procedure for lawmaking. If that part is not suspended, it means they will be bound, and they don't have the kind of setting. No, as a matter of fact, the military government is not set in a democratic way, so they can't have those things that the constitution provided for lawmaking. So naturally, it's not suspended. Otherwise, if not suspended, whatever law they make, the court will strike it down. Then another important part of it is the part of constitution that says that it is supreme. You know, it is supreme, and any law that's made contrary to it will be null and void. That part also is suspended. So nobody will be able to challenge them. As a matter of fact, in some cases, they also ensure that the power of the court, the decision of the court is ousted, you know, such that if anybody goes to court to go and challenge anything that they have done, the court will say that they don't have jurisdiction because they have been ousted. No, but when you do your constitutional law, you come across areas where the courts were ingenious, you know, using the constitution or even their decrees to bring down their actions, because you were talking about actions carried out that are not in line with the constitution. As a matter of fact, even when they now decrease and they oust the decision of the court can still look at it. Sorry, 1 minute. I'm resuming because this is where I didn't want to. So just hang in there.
okay, that's all.
No talking.
Nazareth. Hello. Hello.
Sir.
Can, huh? Class rep, I said the class rep should always stand by to respond when I speak. I need a response. Is anybody hearing me? Am I communicating?
Yes, sir. Yes, sir.
I need response, please. I need response.
Yes, sir. Yes, sir. We can hear you.
Yes, sir.
Okay,
Yes, sir.
thank you very much. Thank you very much. So I was explaining that the military government is not programmed to administer a country in a democratic manner. So if they do not ensure that parts of constitution are suspended, then it means they cannot rule effectively. Because whatever they do, they don't suspend the judiciary. They suspend the legislature, they suspend the executive, and they suspend all the processes having to do with those people. You understand that even the president, under the constitution, there are rules and regulations that guide him. He can't take steps anyhow. There's instances whereby he has to go to the legislature for permission to do one thing or the other, especially if he has to present the budget. For military, there is nothing like that. Military is like a dictatorship. As a matter of fact, in the military, the legislature and the executive are rolled into one. So, and they must also act under a law. So the way they can effectively act is to first suspend the laws that are not compatible with military rule. So they suspend some parts of the constitution having to do with the legislature, with the executive. And even for the judiciary, they also have laws that will say that the judiciary is ousted from looking into certain things. So even if you have a right respect to that thing, the judiciary cannot look at it. And we all know that the Constitution is supreme, Section 1. And anything that is done contrary to it or inconsistent with it would be struck down. So that part of the Constitution itself is suspended. So the Constitution is no longer supreme. It is now the military that is supreme. That is, and they usually have the Supreme Military Council. So they have their name, Supreme Military Council. That is the first the lawmaking body, and they also have the governors and also then the president or head of state. It was Babangida that came up with a military president. No, so the military must necessarily suspend some parts of the constitution, but there are parts that are not suspended. For example, parts having to do with fundamental human rights. Those are universal provisions. Those are universal provisions. But at the same time, they still find some ways to ensure that, so usually when they don't suspend that part, they cannot come up with the decrees, to give them power to maybe detain somebody for 5 months. And when they do that, that decree will now have a provision saying that the courts cannot look into it. So that itself is a provision by which the courts are excluded from looking into certain things. So Daniel Kunke, can we have your question, please?
Yes, sir. Good morning, sir.
Yeah, go ahead.
Sir.
Yeah.
So, sir, you said something about when the ministry comes in, there are some parts that are suspended.
Your network, I don't know whether your network or my network. I can't. You have to please rewind. Can you rewind, please? That was a glitch.
Sir, can you hear me, sir?
Yes, I'm trying to get to. Go ahead.
Okay, is it better now?
Yeah, better. Uh-huh.
All right.
This one-
So as I
Yeah.
was saying, so you said something about when the military comes in, they always suspend the part of the constitution that makes it like supreme and higher, like the ones that makes the constitution itself above every other law. And you also said something about some parts are not suspended, which includes like the chapter 4 of the constitution, which includes fundamental human rights. Also,
Yeah.
sometime when we're doing our constitutional law class, our lecturer, Dr. You told us something that there's a point whereby the military says something, but when they comes in, the decrees and the edict are above the constitution itself, and constitution becomes subordinate to their own decrees. So, does this also mean that chapter 4 is above their decree, or like chapter 4 still remains subordinate to their decree? Like, I don't know if you understand what I'm trying to say. Since
I
chapter 4 is still
do.
part of the
I,
since
I
the
do.
chapter
I still.
Okay, okay.
Yeah, yeah. Daniel, I got that. Even before you
All
ask your
right.
question, listen. Before you ask the question, I already gave an instance that even though chapter 4 is not suspended, which preserve people's human rights, they can enact a decree that will impact on a part of chapter 4. For example, under chapter 4, you can't detain somebody for more than 48 hours before you take the person to court. 24 hours
Okay.
if the court is close by, 48 hours if the court is not close by. But the military can now make a decree, to say that they have a right to detain a person for 3 months. Are you with me? So when they make
Yes, sir.
that kind of decree, in that decree, please, I'm busy now. Can you please come back later? Who is it? I'm in class. Ah, báwo ni? Okay. Please, class, just hold on. A colleague would like to see me briefly. Just hold on. Daniel, I'll back to you.
So now, how are you? Lovely to see you. How have you been, God? How are you? See you. Yeah, I didn't see that.
Yeah, okay. I'm back now. So I made that point even before you asked your question that even though that part is not suspended, but the decree generally comes in terms of validity, comes ahead of any other law. Are you with me? So they can use a decree to even override any part of the law, enter a constitution that's not suspended. And when they do that, the courts cannot look into it. The court can look into it. As a matter of fact, in the past, they have made a decree to affect just a particular person. Laws are not made generally in that form. You don't make maybe you are getting me say law against so over here. No, the laws don't allow it, but decrees can do it. So to a large extent, even though those aspects are not suspended, they can use a decree, to suspend it in particular situations. And when they do that, the there's a general decree that suspends government, but they can have specific decrees that would suspend particular parts of the parts that are not suspended itself. So, and when there is such a decree, the decree takes precedence over over that part of the law. So the decree says they can now arrest without warrant. They can now arrest and detain somebody for as long as they want, and that the court no have power to look into it. So that decree will take effect over the provision of the law that guarantees that right. You understand?
Yes, sir. Yes, sir.
Hello, Daniel. I hope the point is made.
Yes, sir. I understand you, sir.
Daniel, speak now. I hope the point is made.
Yes,
So that
sir.
I make progress. Okay, thank you. So we want to make progress now. So we just want to look, although some of the points have been made, but I just need to also discuss the Constitution as a source of law. I made the point that the Constitution is a very vital legislative instrument. So it is the law by which the validity of all other laws is gauged. So any law that's been made by any legislative house that does not comply with the provision of the Constitution will be struck down as being inconsistent with the Constitution. Maybe the entire law or perhaps a part of it. So the Constitution as a whole, consists of system of laws and customs and conventions. It defines basically the composition and the powers of the organs of states. The organs of state, the legislature, the executive, judiciary, and also it regulates the relationship. How does the legislature relate with the executive? How do they relate with the judiciary? The judiciary, for example, has power to review the powers of the executive and also that of the legislature. The legislature, for example, will make laws, but the laws must be in line with the powers conferred on them by the Constitution. So if they do anything outside of it, using the provision of the Constitution, whatever they have done will be struck down. And apart from the fact that the Constitution regulates the relationship between the organs of government, it also regulates the relationship between them and private citizens. And private citizens. So that's why you found out that they cannot make laws, that will cut short the rights of private citizens as provided and sanctioned by the Constitution. So if you look at the Constitution, if you speak of the Constitution, you look at it first from the content. Then you also look at it as a document containing that content. That is talking in terms of like you are holding the book. This is the Constitution. By the time you get to second semester, when you are doing legal methods 2, you are going to get to know decision between the different sources of law, the formal sources and the material sources. But I don't think you should bother yourself too much about those ones at this point in time. The Constitution in Nigeria is written. All the constitutions that we have in Nigeria, they have always been written. And the Constitution is supreme. I made the point earlier. Is supreme. And all other powers, all other laws, government functionaries, persons in Nigeria are subject to its binding force. So everybody must act in accordance with the provisions of the Constitution. And the point was made also that if any law is inconsistent with the provision of the Constitution, it's not just any law, even conduct, the act of any person. If it is contrary or inconsistent with provisions of the Constitution will prevail, and that other law void to the extent of that inconsistency. I made the point before that Constitution is superior to all other laws, and it regulates the powers of the judiciary, the executive, as well as that of the legislature. So you can look at the case of INEC and Musa. There are several cases actually emphasizing the supremacy of the Constitution. So I'm sure in your constitutional law, a lot of them or some of them must have been cited to you. So you can look at INEC and Musa. It's reported 2003 10 WRN1. Then you can also look at Momo and Senate of National Assembly. Momo and Senate of National Assembly reported 1981 1 NCLR at page 21. So also take note of all other cases. You can also do your research in that respect and get decisions that emphasize the supremacy of the Constitution. But before I proceed, I want to read an excerpt from the case of INEC and Musa. I just read it so that you listen, just to emphasize supremacy of the Constitution. So the Supreme Court held in that case, that's on the supremacy of the Constitution and the consequences arising from it. That is in relation to the powers of the National Assembly. Supreme Court stated as follows. First, all powers, legislative, executive, and judicial, must ultimately be traced to the Constitution. Secondly, the legislative powers of the legislature cannot be exercised inconsistently with the Constitution. Where it is so exercised, it is invalid to the extent of such inconsistency. Thirdly, where the Constitution has enacted exhaustively in respect of any situation, conduct, or subject, a body that claims to legislate in addition to what the Constitution has enacted must show that it has derived legislative authority to do so from the Constitution. Fourthly, where the Constitution sets the condition for doing a thing, no legislation of the National Assembly or of a state House of Assembly can alter those conditions in any way, directly or indirectly, unless, of course, the Constitution itself, as an attribute of its supremacy, expressly so authorized. However, it is described where the Constitution has covered the field as to the law governing any conduct, the provision of the Constitution is the authoritative statement of the law on the subject. So you can see how powerful the Constitution is and what will happen to any conduct that goes against the provisions of the Constitution. So even in amending the Constitution itself, the provision of the Constitution on its own amendment must be followed. So you can't just amend the Constitution anyhow. You will note that even now, the National Assembly parts of the Constitution. And part of the provision is that after the amendment, this amendment must go through, must be taken to all the House of Assembly, and you must have a percentage of those houses agreeing to that amendment. So you can see that it's quite a long and tedious process. Class rep, can you confirm that you can hear me at this time?
Yes, sir. I just started hearing you now.
Okay, good. Because there was a glitch and the link was cut, but I think it's back now. Yeah. So I think the point I was making is that the constitution itself, the constitution is superior to all laws, and any acts outside the constitution or contrary to it or inconsistent with it will be struck down as being invalid, null. The way we put it in law, it says null, void, and of no effect whatsoever. So the constitution, contains both the provisions and also is a document. It's a material. Like I said, you understand those distinctions when you do legal methods in the second semester. So the Constitution is generally described as the ground norm, the organic law of the land, the ground norm. As a matter of fact, we call it the Fons et Origo. Fons et Origo. That's saying the source, the Fons et Origo, the source from which all other laws, emanate. So that's the foundation. So any law does not come out from the Constitution. That is to the fact that the law is not made according to what the Constitution allows, then that law cannot be law in the strict sense of the word under the Nigerian Constitution. And that's why the Constitution provides protections for us as Nigerians under Part 4 of the Constitution. And you can't, except under a military regime, any action of anybody, whether for an individual or the legislature executive. In fact, the judiciary, if any judge, any particular court does anything that goes outside of the powers or which impacts negatively on the fundamental rights of a person, another court will strike it down as being unconstitutional. And the aspect that concerns the court more is the area of a fair hearing. As you proceed in your studies, you will come across, when you study fair hearing, you will see the different aspects of fair hearing, especially in procedural matters. So fair hearing does not consist in not hearing somebody at all, no. But if you hear the person and you refuse to acknowledge the arguments of the person, whether you agree with it or not, it is not fair hearing. Meaning that you decide to push aside the person's argument and consider it. That's not fair hearing. So you can see that even a judicial body or judicial personnel can also breach the provisions of the Constitution. And it will now be incumbent on the higher court to say, yes, you have not done well because you have acted outside the provisions of the Constitution that guarantees fair hearing to a party. So that brings us to the end of the lecture on the Constitution as a source of law. So I think I already made the point that Constitution itself can be amended. So the fact that it's supreme does not mean that it cannot be amended. It can be amended, but it has made provisions on how it can be amended. So those provisions must be complied with for the amendments to be valid. It's very, very important. So now we want to proceed to, I think we should now move on to, okay, let's deal first with a primary and subsidiary legislation. Primary and subsidiary legislation. We all know what legislation means now. We know it is law enacted by a body authorized by law to enact the law, to give the law. So if somebody who does have the authority claims to have enacted the law, then that law will be invalid and that action itself invalidated. Now, what is a primary legislation? Primary legislation, they are also called statutes. And like I did say, legislation can be primary or it could be subsidiary. Now, legislation emanates from legislative bodies. We have spoken about them. The National Assembly, which has the Senate and House of Reps, or the States of Assembly, which serves the states. And in the military government, you have their equivalents. And we are talking ordinarily, we should not be talking about military government again because we don't expect our military government in Nigeria. But with developments in some other countries around us, nothing can be ruled out, even though it's not our desire to have a military government. The truth is that no matter how bad the national government is, a military government should not be our option. Because you can say that, okay, you are going to have a benign head of state. But experience has shown that there is no benign military government because whatever they ask you to do is what you do. And they take your rights away. And you can't do anything about it. If somebody is detained today, somebody can go to court and say, I've detained him beyond the days that the law prescribes. But for military governments, once they make their decree and they say the court can look into it, then the person will rot in prison or in detention, as the case may be. So the primary legislation is the legislation that is enacted by those main legislative bodies. The House of the National Assembly, that is the Senate House of Representatives, or the State House of Assembly. Therefore, the military governments, they are equivalents. You have the Supreme Military Council. They issue out the laws. And those laws in Nigeria, they have answered several separate names. At the time, it used to be ordinances. Then you have acts, you have decrees, you have laws, and you have edicts. And that is depending on the enabling authority. That is the political nature of the country and the authority that issues the law. We are going to be discussing those ones maybe in greater detail soon. So those are the laws that emanate directly from the lawmaking body. They are the primary legislation. So I'll give you assignments for you to have a practical feel of it. You have to go to the library. You check the laws of the Federation. So there you are going to see the laws enacted, by the House of Assembly and Senate, also by the state laws. For state laws, you can check the laws of Lagos State, laws of Oyo State. Those are primary legislation. Then, what is a subsidiary legislation? This one can be defined as legislation made by a person or body other than the sovereign parliament or government of the state or federation, by virtue of powers conferred either by statute or by legislation, which is itself made under statutory power. So let me just explain. For example, you have the principal legislation, which prescribes the law. That the legislation comes out of the National Assembly, for example. If for example, we have a law on aviation, or we have a law on we have a law on agriculture, we have a law on environment. Those laws will have been enacted by the legislative body, either at the federal level or at the state level. Now, laws, even voluminous as they may look, we always find out that there are still aspects of it that they cannot include in that law, in the principal law. That's the prime legislation. So what the law does is that primary legislation will now empower some official, maybe the minister, maybe the commissioner, or perhaps even the CJ, to make rules and regulations pursuant to that law. If, for example, okay, let me use that of the one that people should be very familiar with is judiciary. Every state has its high court laws. We also have rules of courts. Rules of courts are made by either the CJ for federal courts or the chief judge. The chief justice, that is CJ, at the federal level for federal courts, maybe for Supreme Court. For Court of Appeal, the law can say it should be, because there's a Court of Appeal Act itself. Instead of that Court of Appeal Act, the law will give power to the president of the Court of Appeal to make regulations. So the rules that we use, they are made pursuant to the main law, which is the primary legislation. So that rule is a subsidiary legislation. But the judge, the CJ, the Chief Justice or the Chief Judge cannot make rules of court except there is a power conferred by that court law to that effect. So subsidiary legislation is legislation made pursuant to power conferred by the primary legislation. So if, for example, if you go to the library and you carry some of the laws of the Federation, if that law has subsidiary legislation, you see it immediately after the main law. They will call the right subsidiary legislation. And you are going to see subsidiary legislation, and you are going to see the name of the person that enacted it. So that's the essence of subsidiary legislation. So it is law. It's legislation that is made by person or body other than the main lawmaking body. But that power is conferred. That power is carried out based on authority conferred by the main law, authority conferred by the legislative body. To say, okay, you, CJ, you have power to make rules of court. If you talk of aviation, for example, you can give the Minister of Aviation the power to make regulations that will regulate activities at the airport. So because the law itself cannot contain everything, as a matter of fact, there are things that you can't be sure of. Events can come up. The events can come up that must be reacted to immediately. And that's where revenue comes in. Because before you now carry the thing as law and take it to the assembly, it can take forever. Meanwhile, there's a need to put in regulations, to either to stem a conduct or to ensure that something is done, urgently. So that's the essence of the subsidiary legislation. So subsidiary legislation is legislation made pursuant to powers conferred by the primary legislation. So basically, what we call it subsidiary, it means it is superior to the primary legislation, and legislation that empowers it and also repeal it. So if a power is given to maybe the CJ to make rules of court, if the legislative body says, okay, we don't want the CJ to do it again, we want the Attorney General to do it, they can amend it, remove the power from the CJ and give it to the Attorney General, and that will be it. Meaning that CJ will not be able to make the rules again, you know. So that's basically what it means. So it basically derives validity and authority from the substantive law, you know. Otherwise, there will not be capacity to enact that law. So it's very, very important. And subsidiary may take different forms. It could be regulations, you know. They can have aviation regulations. It can be rules. It can be orders or bylaws, you know. But basically, they derive their powers from the primary statute, which is also called the enabling law. So if somebody makes regulations must be made under the enabling law. Otherwise, it will be taken as a null and void. So I made the point, the regulations made by administrative agents of government, of the executive arm of government, you know. It could be rules of procedure made by courts. For example, we have high court civil procedure rules in Lagos State. The rules are made by the chief judge of Lagos State, just like they are also made in all other states. It could be municipal bylaws. That's laws made by local government councils to regulate matters within their sphere of control. And that one, for example, that one will have been made under local government law, because there's a local government law, you know, that regulates, that is for all local governments. So there will be powers in that law empowering the local government chairman to make rules and regulations or bylaws that will operate within the confines of that local government. Then also it could be regulations, you know, by professional bodies. For example, as lawyers, we have our rules of professional conduct. Those rules were made pursuant to the Legal Practitioners Act. So if the practitioner does not make that power, you know, maybe for MBA, for him to make those rules, the MBA will never be able to do it. So those rules for discipline of professionals or professionals, it could be lawyers, it could be medical doctors, because they also have their law, medical and data council law, you know, it could be for architects, it could be for builders. 1 minute. Hello? Hello? So it could be for builders, you know. So professionals too, usually they are set up under the law. So they have a law that sets them up, you know. So they can now, that law will now empower one of the officials, maybe the chairman or the president, to make rules. For example, in law, we have the rules on professional conduct. We have the rules on professional fees now, which is the one done in 2023. So those rules were made pursuant to the Legal Practitioners Act, which is called the Enabling Act, which we, for purpose of this lecture, is referred to as primary. Now, so those are the examples of subsidiary legislation. Now you must note that there are two legal limitations on the powers to make subsidiary legislation. that is one is imposed by the doctrine of ultra vires. When you in constitutional law, I'm sure if you have not done it, you will do it. That is the doctrine of ultra vires, and also the maxim delegatus non potest delegare. Ultra vires, what it says is that your powers are curtailed, your powers are streamlined. So if you act outside those powers, then you'll be taken to affected outside of powers, beyond your powers. That's what means ultra vires, beyond powers. So if it's found out that because the primary law will have given you the powers, it will have stated the powers that you can exercise over what. So in exercising that power, if you act outside of the powers conferred, then that regulation or something will be struck down because it has failed to follow the provisions of the law, enabling that officer or official to make it. So to that extent, it can be struck down as being ultra various. Then the other one is delegatus non potens delegare, and that applies in this instance for legislative powers. So and the principle of law is that when power has been delegated to you, for example, is the main power, is in the hands of the legislative body. So what they have done is because they can't be everywhere and they can't make laws almost every day or to take care of day-to-day activities in a particular aspect or section of the economy. So they now delegate that power to whoever they are mentioned in it. So when that power is delegated, what they can do
Hello, sir. We can't hear you again. I said he's having network issues, but it's coming.
Did you later get my own stuff? I gave like this thing, but like okay. I did. I found it. It's actually beside that purple one. You just put the well, yeah, your voice is your voice is what is it? Let me know first.
Come here. Pô, mano, Igor. Obrigado.